Welcome, everyone. Thank you so much for joining today. Oh, there's one more person. I'm Giovanna Shea. I'm the Litigation and Advocacy Director here at Greater Hartford Legal Aid. We're so happy to have folks join today to prepare to provide pro bono services in the sadly anticipated eviction surge. And we have two very experienced presenters who many of you know, Attorney Cecil Thomas, Attorney Nancy Ronick, great depth of experience in housing law and many years of practice here at Greater Hartford Legal Aid, including individual and systemic representation. And they have an interactive presentation prepared to really help folks dig in and get prepared to help people in these critical times. So I want to welcome attorneys from Robinson & Cole, McCarter and English, Shipman and Goodwin, also others with their own practices, and say thank you for reviewing the materials and for making the time and for being willing to serve in this capacity. And with that, I'm going to turn it over to Attorney Thomas and Attorney Ronick, and I'm going to mute myself for now and monitor the chat and also monitor the participants entering. Thank you again.
Thank you, Giovanna, and I want to say welcome to everyone. I think both Attorney Ronick and I are really excited when anybody wants to get involved in housing, and given what we are expecting in the coming months, given the likely expiration of the eviction moratoriums at some point in 2021, we certainly appreciate all the help we can get. I hope that all of you have had the opportunity to review what is functionally part one of this training, which was the link that was sent around to you. Certainly welcome from you all at the end of this training or in follow-up conversations, feedback on that training. This is designed to build off of that, to get a little bit more into the sort of the nuts and bolts of representation, working with our client community and client population. And we'll close, the majority of this training will be an interactive presentation where we'll put up some notices, we'll put up some issues, and hopefully just invite you all to identify what those issues are, and we can discuss and work through some of the problems. There's no way that we can do this in an exhaustive way within an hour and a half, but certainly part of our goal here is to try to introduce you to the way that we look at cases and some of the issues that we deal with when we're representing our clients. So without further ado, I'm going to share my screen and we'll walk through this presentation. Just in reviewing very quickly what we'll cover today, we're going to talk a little bit about some of the considerations in representing indigent clients. We'll go back very briefly over some of the governing principles of Connecticut summary process law, which you were introduced to in the prior video. All of you should also have the manual that was prepared by the various legal aid programs, which should be a helpful resource to you as you're undertaking this representation. We'll talk a little bit about some practical effective representation tips. We'll talk a little bit about some of the particular issues that arise when you're representing a tenant in a subsidized housing program. And then we'll get into some information about the rental assistance programs that are either currently open or expected to open within the coming weeks. Work through some hypotheticals that'll give you the opportunity to issue spot and engage and discuss some of the problems, and then open it up for Q&A at the end. So just getting started with considerations and working with our clients. I mean, all of you are experienced lawyers. You have familiarity with working with clients, understand the dynamic, the nature of that relationship. I think one of the overlays, which certainly isn't particular to our client population, but which is certainly more likely with our client population, is that they're often in a state of crisis. And the eviction or the bringing of the notice to quit is often just one in a series of events that has a devastating impact. And I think, as I covered in the first session, the impact of the eviction itself is well known among our client community, and the bringing of that eviction is extremely stressful. The implications of it, the effects on mental health, well-being, housing stability, all of that's well documented, and certainly that's when you're going to be meeting that client. Oftentimes they're dealing with other challenges simultaneously. And so as I indicated, that the eviction is really just a part of that overall set of complexities. And oftentimes what we see with our clients is that they're making decisions in that sort of crisis management mode, which oftentimes we have the privilege, I think, from our positions of having more long-term decision-making to think about sort of forward thinking and putting more planning into place. And it's really a product of occupying a certain level of privilege. And often our clients, because of those issues that they're dealing with and the many crises they're managing, don't necessarily make the decisions that you or I would make in handling a situation. I think the best thing that we can bring, to borrow from some gym advertisements, is a judgment-free zone, one that sort of understands that why clients are dealing with the issues that they're dealing with and why they might make some of the decisions that they're making, without necessarily judging why they've made those decisions. Poverty is incredibly complicated. And so what I would say is that many of our clients are interacting with systems that are designed or at least nominally in place to assist them. But from a practical perspective, those systems are often so complicated that it can feel very frustrating to our clients to navigate those. And so if a client has gotten to you, they've won some sort of proverbial lottery, in the sense that 90-something percent of 90+% of tenants facing an eviction in Connecticut go unrepresented. And so the challenges of accessing counsel, of meeting with you, those may also be complexities of sort of getting to you, can be really challenging. Oftentimes, like I said, those other systems that are designed to assist our clients are very complicated. There are a lot of pitfalls where our clients are caught up, and oftentimes individuals that are in place to assist, at least in terms of the function of their position, because of the complexities of those programs, end up in somewhat of a not quite adversarial role, but position in which the client certainly perceives that somebody who's there to help them is really out to, quote, get them. And so I think that may be some of the challenges that you're dealing with when you meet with that client for the first time. The distinction between you and some other element of the, quote, system, or the sort of complicated systems that they have to navigate, is difficult, and you may appear to them to just be a part of that system. And oftentimes when you're navigating a system that they are uncomfortable with or unfamiliar with, your confidence and comfort in that system may give the impression to them that you are a part of that system. And so Nancy and I often get the experience of sort of being challenged on that front. I think part of what you have to bring to that is a degree of empathy and compassion for the clients, and understanding that that challenge to you is not really about you, and that oftentimes we sort of have to take that and roll with it a bit to develop rapport and inspire confidence over time. Nancy will talk a bit about some of the myths that our clients have about the eviction process and some of the practical barriers that are currently in place.
Yeah, I'm just going to follow up with what Cecil was just saying about building rapport with your client. It is difficult because they often have difficult relationships with other people in authority, and they get assigned to us, and suddenly we're just another person in authority telling them what to do or giving them bad news. So in addition to everything that Cecil has told you, which I totally agree with, one of the things that I found is that people don't always tell us everything that's going on. They withhold facts, or they obfuscate at the beginning because they don't really trust us. And you have to build that level of trust and then ask some of the same questions again, and the story may come out. Clients don't instinctively understand an attorney-client relationship. It's not something that they may have had experience with. So it's probably worth spending a minute or two just explaining, how an attorney-client relationship works, and confidentiality, and judgment, as Cecil said. But time and time again, I found that folks will change their stories as I get to know them a little more. And getting the full story out at the beginning is sometimes difficult. So also, one of the difficulties that we found over the years is that there are a lot of myths about the eviction process, both with the general public and our clients and our client community and our clients' families and friends. And there are always folks who are telling our clients how it all works. And there is such a thing as the internet, and our clients do go online and do their own research sometimes and bring in stacks of papers telling me how the case is going to go when it's not applicable at all. But just a few of the really prevalent myths that we still hear, I heard when I started years ago and I still hear today, is that the process is going to take 3 months. It's going to take 3 months for the eviction to go through. And it can take 3 months, it can take longer, but I assure you, most cases do not take 3 months. It's going to move much faster, and there's no guarantee about the eviction taking any amount of time whatsoever. The pace is the pace, and each case is different. But folks continue to think that just by going through the process, they're going to get a certain amount of time. There are also lots of myths about things like the court won't put me out, the judge won't put me out in bad weather. It's the middle of winter, we're having a blizzard. I won't be put out because I'm disabled, or I won't be put out because I have small children. And those are absolutely untrue. The court evicts people every day in each of those circumstances. Lastly, folks sometimes think that if they are put out, there's a place to go. And that's really one of the hardest discussions that I have with people, is thinking about, I try to get people to start thinking about options if it looks like we're not going to be keeping them in their current situation. And there is a big misconception with the general public, with the court system, and with plaintiffs' attorneys, that there is a vigorous shelter system out there that's going to take care of folks if they're evicted. And yes, we have a shelter system, but the shelter system is in crisis like every other system in the state. And it's very rare now for a person to be able to get a shelter bed in Connecticut without getting on a wait list. And we've had situations in our office where folks are literally on the street, having been put out by a marshal, and calling 211 looking for shelter services, and there are no beds available. I've had people told that there's at least a 2-week wait list. So do not think that if your client is going to be put out, or don't let your client assume that there's a system that's ready to catch them if the case does not go the way that they're hoping. And just practical barriers to dealing with clients. It's especially true in COVID days when we're all meeting remotely. But I think everybody needs to think through, how will they meet with clients? Probably you'll be able to talk to clients over the phone. Most of our clients do have phone service. Some of our clients have smartphones. Some of our clients still have flip phones. Some of our clients have minute limitations and have limited ability to call us. I just would urge you to sort of consider those things when you're dealing with doing a client interview or meeting with your client. It's not always going to be able to be remotely like we're doing on a Zoom call. Even if the client has a smartphone, they may not have internet service. And it's difficult. Our clients are facing lots of issues with a very deep digital divide now in trying to access court hearings. That's going to be a whole nother challenge, thinking about court hearings and how your client can participate remotely or perhaps in your office, depending on each person's comfort level and rules of your offices. I hadn't been coming into the office. As more clients are needing help, I've been coming into the office more and more. And you can see I'm in a big conference room. So I have had digital hearings, remote hearings with folks in the same room. We wear masks. We do the hearing on my computer. That's worked out fairly well when it's just me and one other person. When there are other witnesses, it's going to be much more difficult. So I urge you to think about some of those things. Also think about ways that a client can get you documents. They may be able to drop papers off to a Dropbox or to a reception desk or some other way. I've also sent postage prepaid envelopes to clients, had them send their documents to me. I copy them and I mail them back. That takes time, but it's doable. I've gone to clients' houses, I've met clients outdoors, and clients have come here and met with me in person in a large room. So I think that's all personal preference, but those are some of the things you're going to have to think about, how you're going to meet with folks. Do not assume that they're going to be able to meet with you by video conference. that will be the rarity, and that will be a welcome rarity, but it will be rare. Mostly you'll be meeting with folks by phone. So think about those things, and we can talk some of the hints we have in how to deal with folks over the phone. We can talk cases through with you as you get your own cases. Feel free to call us, and if people have questions, throw them into the chat, and Giovanna can try to monitor that, and then at the end we can pick up those questions, hopefully.
So you all have seen these general principles in the presentation before this one, but just to remind you all going into today's discussion that summary process is a special statutory proceeding. It's a creature of statute, and so therefore there's a bit of a balance there, and that balance is both the fact that landlords have been given this expedited and extremely special remedy. Median time frame for evictions typically is under 30 days, and so I can't think of any other civil process that runs from start to finish in Connecticut within that time frame. And that balance is about the preservation of that, the due process protections, and that's what we do as lawyers representing tenants facing evictions. And so that narrow construction and strictly following the statute is a big part of what we do as lawyers representing tenants. And so you'll see the Jefferson Gardens case and the fact that those adherence to those pre-termination requirements and preconditions set by state and federal law, you're going to want to pay very close attention to those. The only issue before the court is the issue of possession. So there may be other issues that could be dealt with in a settlement, but generally speaking, or exclusively speaking, when the judge decides the matter, the only question is who gets possession. Is it going to be the landlord or the tenant? And again, because of that jurisdictional element of the notices, the landlord is required to prove that compliance. And if you find that the notices don't comply with the timelines or with the statutory requirements, you'll want to raise those issues as motions to dismiss to attack the jurisdiction of the court. The practical benefit of that, obviously, is that you are doing what you can to dispose of this case to the extent possible in a way that's favorable to your client. And that notice to quit has to be unequivocal, and that means that there can't be mixed messages sent in the process that once a landlord has decided to terminate the lease is terminated, and the landlord needs to proceed under that course. And can't be sending mixed messages about their intention. I won't spend a ton of time on this slide because you've all seen it, but we use this as a reference point just to be able to look at a case, identify what stage in the proceedings you are, and to look carefully at those dates, because failure to comply with those statutorily required dates is a jurisdictional issue and something you should raise in that case to try to obtain dismissal or other leverage in the defense of the case.
I keep telling Cecil that chart scares people because of all the arrows and boxes, but it's really helpful just to have on your desk as a reminder. And it's really not scary, it just looks scary. But so yeah, one of our, a lawyer who I worked with for many years did a handwritten copy of that. And one of the first things Cecil did when he started working at Legal Aid was to put it into this format. So I'm always happy to see the chart. It really is great. Put it up on your bulletin board and you'll look at it multiple times. I'm going to talk a little bit about practical tips, and I'm hoping that Cecil will jump in, and Kelsey Bannon, who is a relatively new attorney to the housing unit in our office, is also on the call. So Kelsey, feel free to jump in if you have any practical tips that you might want to tell folks about. So controlling the pace of litigation, that I think is one of the hardest things to learn when you start doing summary process defense work. It's time is what our clients need, and even if whether our clients are going to stay in the apartment and try to work out a resolution with their landlord, or whether the ultimate goal is to have the client move somewhere else, perhaps have a soft landing somewhere else, it's important to do what we can to give our client that time to make decisions and do some planning. So we can't, as defense attorneys, always control the pace of the litigation. That's mostly controlled by the landlord's attorney or the landlord, but there are things that we can do. First of all, it is not a dilatory tactic to wait until the last minute to file your pleadings. In fact, it's the best practice. It's the only practice. I think that attorneys sometimes, people who are well organized, will want to be prepared and will balk at the idea of waiting until the last minute because that's so nerve-wracking to do. But really, that's something that will help your client. So think about when your appearance is due. If you have a return date of the 10th of the month or the 12th of the month, your appearance is not due until 2 days after. So don't file it until 2 days after. Don't file it 3 days before. That will speed the case up. It won't help your client. And every day that we can slow the pace down, there may be a hearing that then doesn't get held in the month of January and is put over 2 weeks later into February. And that may be 2 weeks that the client needs to find a new apartment or to get the money available to pay the landlord and stay where they are. As a general matter, we do not file pleadings unless or until the plaintiff files a motion for default for failure to plead. So in summary process law, motions for default trigger a 3-day pleading rule. You have to plead within 3 days of the filing of the motion, which is a quick turnaround. So you want to try to have your pleading in mind and perhaps even drafted ahead of time, but do not file it unless the opposing party files the motion for default. Now, again, that can be nerve-wracking. So it's really important to monitor the case, make sure you have an email alert on the court website so that you get notices of filings quickly, and then be prepared to respond quickly. But filing, it is not a dilatory tactic to wait for that motion for default. And sometimes plaintiff lawyers, if they don't do a lot of this work, might call you up and say, are you going to file a pleading? Because they're not used to the fact that the defendant waits until the motion for default. But 95% of the cases that you get are going to have somewhat experienced attorneys as plaintiff attorneys, and they will expect you to wait. They will file the motion for default, trust me. It's not rude, it's not dilatory. So we take our time within the practice book rules because it has direct benefits for our clients. And then I think, Cecil, were you talking about the collateral consequences?
Yeah, I can pick that up. I mean, I think that part of the thing to remember is that these evictions, an eviction record takes on a life of its own after you get through that case. And so oftentimes, even cases that we've been successful in winning, prospective landlords will look at the record of that case, and will use that as a basis to deny a tenant access to another unit in the future. And that can happen. That can have a life of its own for years beyond the original case that you may handle. And so, practically speaking, if you're able to obtain a better outcome, if you're able to get a case dismissed, there are different dispositions that end up being entered into those, both into the judicial records as well as into those third-party services that collect that information. And so while we can't obtain the erasure of a case, practically speaking, for example, a dismissal will result in that case being dropped off the online docket much faster than a judgment would. And so, you want to think about sort of what the client's goals are, what the broader impact is going to be of the case, and to the extent that we're creating, as Nancy said, some opportunity for them to resolve the situation in a way that's in their best interests. That's ultimately a great service that you can do. Remember also that once the tenant has vacated the unit, the case is moot. The only case issue is possession. And so thinking about those different sort of resolutions to possible resolutions that result in a victory for our clients, it may not always be after a trial. There may be other routes to something that is a functional victory for our clients that allows them to preserve the tenancy or find a better situation for themselves. A couple things that we'll just flag very quickly, but we won't spend a lot of time on, is that currently there are 2 moratoriums in place. One is the Connecticut eviction moratorium that's set to expire on February 9th. There are certain carve-outs from that that allow certain cases to move forward. The status of that moratorium is unsure right now. It's not clear whether the governor will have the emergency powers continued to extend that, but it is something to watch. And so to the extent that you take cases between now and February 9th, may be circumstances under which there are defenses that arise because of the language of those moratoriums and executive orders. There may be defenses arising from the CDC moratorium that expires on January 31st if a declaration is filed. If you have one of those issues and want to talk to us about it, just reach out. It's a bit much to cover today. The other thing to remember is that the CARES Act had certain eviction moratorium and had certain requirements, notice requirements associated with it. And so Judicial has put out an affidavit of compliance that a landlord is required to file. It's linked here. You can find it on the Judicial website. But when you do start taking cases, even though the CARES Act was, I think, effective March 27th of last year, and the actual moratorium that it provided expired, I think, 120 days after that date, there may be residual protections that apply to our clients or limitations on the remedy of summary process that arise because of the CARES Act. And so take time to look at the CARES Act. If you get that type of case, look at the affidavit of non-compliance, or sorry, affidavit of compliance filed by the landlord. Certainly, if the landlord has failed to file such an affidavit, then that would be an issue to raise with the court as well. A number of our clients have different subsidized housing, and so Nancy's going to talk a bit about those different varieties of subsidized housing to help you learn how to identify those programs.
So I'm not going to spend too much time on the nuts and bolts of subsidized housing, and instead I'm going to try to just give you an overview, the sort of the theory behind subsidized housing. It's a highly regulated field, so always remember statute, regs, policies. There's guidance out there, both at the local and HUD level. Also, please remember there are exceptions to just about everything that I'm going to tell you about subsidized housing. It's a maze, but it's not impenetrable. It can be mastered. You just have to sort of work through it step by step. So there are two main kinds of subsidized housing, two main types that I think about. I think about bricks and mortar housing, and I think about tenant-based subsidized housing. So bricks and mortar housing are your typical public housing units. They are units, apartments, or buildings where the subsidy is attached to the unit. So a tenant moves in, they get the benefit of the subsidy. They move out, the subsidy stays with the unit. A tenant-based subsidy is attached to the tenant. And as long as the tenant is in compliance with all of the many requirements for receiving that subsidy, the tenant has the benefit of the unit. They move out of a unit, they take the subsidy with them. I would say we used to have more bricks and mortar housing, typical public housing. We now probably have more tenant-based subsidized housing. Much of the bricks and mortar housing, especially in Hartford, has over the last 20, 25 years been demolished. But bricks and mortar subsidized housing is the public housing that you normally think about, managed and operated by a housing authority, the Hartford Housing Authority, the East Hartford Housing Authority, the Manchester Housing Authority. Most of the bigger towns in the Hartford area have housing authorities that operate and manage their own subsidized housing. Now, again, there's exceptions because there's state subsidized housing, there's specialized subsidized housing, but usually it's managed and operated under the auspices of HUD. It's federal, it's federally subsidized, and it's highly regulated. Tenant-based subsidies are generally Section 8 vouchers. Now, you're going to have folks who will tell you they have Section 8, and many of them do have Section 8 vouchers, but Section 8 has become sort of a term that people throw around as any kind of subsidy. So you will see landlords refer to it as Section 8 and tenants refer to it as Section 8. It might not be Section 8, it might be a different kind of housing. And to make things even more complicated, there is such a thing as not only the Section 8 vouchers that tenants have that sticks with them, there are vouchers that actually stick with the building, project-based Section 8. Like I said, there are exceptions to everything. So I'm not going to go through, you can read the slides, the sites are there. The most important thing I think to do when you have a case is figure out if there is a subsidy. And the easiest way to figure out if there is a subsidy is to ask the tenant how much their rent is. And if their rent is something that seems low, it's probably subsidized. If their rent is $1,200, it's probably not subsidized. But if they say their rent is $127, then you can be assured that that's a subsidy somewhere. Then the next thing you want to do is figure out what kind of subsidy it is. The best ways to do that are, as I said, ask the client. They may be able to tell you. Ask the client for a copy of their lease. The lease may indicate the kind of subsidized housing there is. You can do discovery. If you look at the written materials that were sent around from Legal Services Manual, the housing manual, it'll talk about discovery is allowed in eviction cases. So it's always a good idea to ask about the subsidy in discovery, ask for contracts, and ask for leases. As a last resort, you can determine the type of subsidy by going to the land records in a particular town. That may require an actual trip to the city hall, but it's fairly easy to do. And I found that at least in Hartford, the folks in Hartford are always willing to help you figure out the land record issues. So a little bit about who manages subsidies. And housing authorities are generally the managers of subsidies, but again, there's huge exceptions. In Hartford, we have sort of a unique situation in that Section 8 vouchers are managed through the Hartford Housing Authority, but the city of Hartford also has several thousand vouchers that they are responsible for. Those vouchers, they contract out through an agency called Imagineers. Imagineers is a private contractor with the city, and they act as the housing authority for the city of Hartford. So you might get clients who refer to the housing authority, or you might get clients who refer to Imagineers. Both are considered PHAs, or public housing agencies. Also, we have same situation with the state of Connecticut. The state of Connecticut administers several thousand housing vouchers that are available to tenants statewide. And those are administered through a private contractor called D'Amelia and Associates. And just to make that even more unclear, D'Amelia then contracts with local housing authorities statewide to run their programs. So there's several layers of administration. Again, if you get a subsidized housing case, call us. We can help, we can point you in the right direction. We may know just from the address or the landlord the kinds of subsidies. Project-based Section 8, I'm gonna try to follow the outline a little more now. Project-based Section 8 is Section 8 that sticks with the unit. It has a deep subsidy, meaning the tenant is going to pay approximately 30% of the household income. And there's a whole bunch of subsections of what we call project-based Section 8, new construction, substantial rehab. You don't need to memorize any of that. If you get a case, the lease should tell you what kind of subsidy it is, hopefully. You can always call HUD to find out, and then you want to go right to the regs, because each of these different kinds of subsidized housing has a slightly different eviction procedure. The state eviction procedure applies, but then there are certain additional requirements that are required by particularly public housing or Section 8. There's low income, I'll go back to low income tax credit. That's not a HUD program. That's a program that's actually administered through the IRS. The landlord gives the tenant a shallow subsidy. It's not as good of a deal as a Section 8 voucher or public housing. So then that's administered, as I said, by the IRS. It's not administered through HUD. In Connecticut, those buildings go through GHLA, so you can always call them and find out information about the low-income tax credit program. Hang on. So there are there's also the state RAP program. So the state RAP program, rental assistance program, is modeled after the federal Section 8 program. It's very similar. The rules are very similar, but they're different. It works the same way as Section 8. The tenant gets a RAP certificate or a RAP voucher. Sometimes it's called both. The tenant goes around, finds a private landlord, rents the apartment using the voucher or certificate to pay a portion of the rent. They pay the remaining portion. It's administered through the state of Connecticut, through their contractor, D'Amelia and Associates again. And I've included the portal from the DOH website. There's not only a description of the program, there's also a link to the RAP administrative plan, and it's hundreds of pages of rules about how the program operates, the administration and the operation of the RAP program, and will also list the tenant responsibilities. So if you do have a case where the tenant has a RAP certificate, it's probably a good idea to bookmark that DOH page. And we've also listed the statutory authority and the regulations that apply for the state program. Some of the special considerations for subsidized housing that you want to just think about, or special overlays, are that there are different notice requirements in federal housing than there are in state housing. State housing, as a general matter, requires a 3-day notice to quit, and in federal public housing, there's generally a longer period of time, especially for non-payment cases. Also, there's a cure period for non-payment cases, and I won't get into a lot of the details, but there has to be time given on the notice to quit to give the tenant a chance to cure their default. Tenant also has rights to an informal conference or a formal or informal hearing prior to an eviction. Now, often we don't see these cases. Tenants don't come to us until the eviction process has started. And by that time, they probably have waived their rights to the hearing, the informal hearing or the formal hearing, or any grievance rights. But sometimes we get the cases early enough that they still have an opportunity to ask for a grievance hearing. And the idea is that asking for a meeting or a grievance hearing gives them an opportunity to resolve the dispute before it gets to court. There are also special service requirements that some of the federal programs require. Again, look to the regs. Sometimes the service requirements will require not only an in-hand service of the notice to quit, but also a service of the notice to quit on the subsidy administrator, the PHA, the housing authority. Also, there are federal requirements in some of the programs that notice also be given by first-class mail. So again, go to the regs. Just figure out the program and go to the regs. The other consideration for subsidized cases is virtually all of the subsidized housing providers and all of the subsidized housing programs provide that a tenant can only be evicted for good cause. In other words, a tenant has a due process interest in their housing if it's subsidized. There's a federal interest in that apartment or their voucher, and they can only be evicted if they have a subsidy for good cause, and we've listed some of the good cause requirements. Now, that doesn't translate to folks using a voucher in private housing. That only means good cause is required for people who are renting the bricks and mortar housing. If a tenant has a voucher and is renting from a private landlord, the private landlord can still evict for lapse of time, or your lease is over, we don't want to renew your lease. But a housing authority with public housing or other kinds of subsidized housing cannot. Lapse of time is not a good reason for subsidized housing. So you want to always make sure that whatever subsidy your client has, you want to make sure that you're taking a look at whether or not the allegations of the eviction fall within good cause as listed, or whether it's something that would be considered a no-fault reason, like lapse of time. No fault does not hold for most subsidized housing programs, but the exception is Section 8 vouchers and RAP vouchers. So there's always exceptions. I've also listed just the general, again, types of subsidized housing with a little more detail and the listings of the regulations. In addition to the regulations, each housing authority is going to have a PHA plan, a PHA administrative plan, or for Section 8, or what they call a PHA tenant admissions and occupancy plan. And those are lengthy rules and regulations that each housing authority develops to instruct the tenant on all the rules of the tenancy. And also special rules, if there are special rules regarding any eviction rights or lease rights. So it's a good idea if you have an eviction with a subsidized tenant to figure out where the subsidy is from. You can usually find those documents online. If you go to the Hartford Housing website or the East Hartford Housing website, you can do some searching and find the applicable PHA plan, the administrative plan, or the admissions and occupancy plan, they're called. That's really a starting place for figuring out the particular rights a tenant may have. But if you get subsidized housing cases, or if a tenant, we may refer you a case and not know that there's a subsidy because it's a Section 8 subsidy, and you wouldn't necessarily know that unless you discuss it with the tenant. You know, please feel free to call us and we can give you some shortcuts on how to find out some of the information. I know we've gone over this really, really quickly. Lastly, I just want to point out housing quality standards. In addition to any standards that the town may have as far as conditions of the apartment, the subsidized housing providers also have to meet housing quality standards, which are minimum standards required by HUD for subsidized housing, both private housing that's leased through the voucher program and public housing that's the bricks and mortar housing. So even there may be things that are required by the housing quality standard that is not in the local housing code. So if you are considering raising a defense of habitability to a non-payment case, for example, it is always a good idea to get any kind of repair reports from the housing subsidy provider and take a look at the housing quality standards. Again, they're in the regulations, to see if the landlord may have violated both the HQS and the local town housing code. So just take a look at that also. And the last slide, oh no, that's the rental assistance program, but I just remind you also that in addition to all the federal HQS considerations, the state RAP program also has its own set of housing quality standards, and take a look at the Department of Housing website. So if that's not enough to make your head spin, I don't know what is. It takes years to learn about subsidized housing, but it's really fun if you get a subsidized housing case, because there's often lots of things you can do to develop defenses for your clients.
The other thing to be mindful of is that there are a couple of programs that are either currently in play or are expected to be open just to provide some rental assistance to clients. And so to the extent that the case is about non-payment of rent and you're looking to connect your client with those resources, currently the only program that's open on the state level is the homeless prevention program that requires a notice to quit. It requires inability to pay rent after starting March 1st, 2020 or thereafter. And there is an assessment of your client's likelihood of entering the homelessness system that will qualify them if they meet that criteria for assistance. The most recently enacted stimulus bill, though, did allocate a significant amount of money for rental assistance. And so in the coming weeks or months, we will hopefully see a new rental assistance program opening up in Connecticut. I think something like $237 million has been allocated to that program or for that purpose here in Connecticut. So it's the first time I think we've seen meaningful rental assistance open up. And so oftentimes to the earlier point that we made, that there may be some complexities in navigating those systems, it can be a great service if your clients have applied for that assistance, to just reach out to the administrators of those programs to help them, collect the documents that they need, to submit them to the extent that they need to be done through an online portal. You can often serve as an effective liaison for that supportive assistance. There are various sort of discretionary funds that are maintained by different social service departments in certain towns, by religious institutions or other community organizations. I'm always surprised at the different places that have these small discretionary funds. And so if your client's already connected with an organization or receiving support services from such an organization and needs some help with the rental assistance, it certainly is in their best interest to try to inquire about those programs. So this is the part of the training where we're going to move into more of an interactive issue spotting exercise. So I do hope, just for the interests of keeping this engaging, that you all will participate and highlight the issues that you see, and there are really no wrong answers. To our point earlier, we would like this to also be a safe zone. So we'll start with this notice. And so this is what is commonly referred to as the CAPA notice, delivered pursuant to Connecticut General Statutes 47815. It notifies the tenant that they have violated the obligations of the lease or tenant statutory obligations in some way. And so take a minute to review this notice. I'll give you a hint that there's a couple of problems with it. So let's see if you can identify what those problems are. And if you think you see something, just unmute yourself and pipe in.
No opportunity to cure?
Perfect. That was from, is that Vaughn?
Yes.
You're a bit of
I'm
a
glad I
ringer.
could get one.
Yeah, I was gonna say.
Yeah. So
Teach
thank you. Yes, no opportunity to cure. Anything else? Hint, look at the dates. Okay, so generally speaking, there is an opportunity to cure, and there's a 15-day cure period specified by the statute. So the opportunity to cure, even if it appears to be a violation that does not seem on its face to be something that can be cured, the case law is very clear that notice of the right to cure must be provided. And so in a case that involved damages to the unit, that might be a statement of what those damages are and the cost of repairing it. In a case like this, where there's some allegations of noise or disruption or other issues that affect the sort of peaceful enjoyment of the other tenants, that opportunity to cure may be just an opportunity to discontinue the behavior or to address it in some way. And so notice of that right is really important. Additionally, just getting back to those governing principles, that the notices themselves, because they allow access to this expedited and extremely special remedy of summary process, those dates are really meaningful. And so that 15-day cure period needs to be a full 15 days. Here you have the CAPA notice delivered on April 2nd. The notice to quit, which terminates the lease, was served on April 15th. And so there were not 15 full days between the date of delivery of the notice and the date by which the lease was terminated. The case law is very clear that this CAPA notice has the purpose of discouraging evictions against first-time offenders. So on that first offense that you commit, you do get that right to address that, so you don't end up facing the extraordinary harm of losing your tenancy over a relatively minor set of violations, or even violations that have just taken place for the first time. So you're entitled to that notice, you're entitled to that opportunity to cure, and that 15 days is really important, that the full 15 days is provided. And the failure to do so deprives the court of jurisdiction to entertain any claim that would require a CAPA notice, such as nuisance or a lease violation claim, if the CAPA notice is insufficient. Any questions about this one before we move on? Or Nancy, do you have further thoughts?
I just want to point out as a practical tip, ask your client to bring you the envelope for any correspondence they receive, if they have it. But if you're meeting with the client or they're bringing you documents to copy, they may not think the envelope is important. In this case, it was sent certified and the tenant received it, and so they probably would bring you the certification. But most CAPA notices like this are sent first class, and over and over and over again, we see a date on the letter, which is way different from the date of the postmark. So ask the client to bring you the envelopes, all the envelopes they can find.
Yeah, and you can see from this one, it actually had 2 dates on it, the 25th and the 27th of March, but then was actually not put into the mail system until significantly later, resulting in the delivery on April 2nd.
So,
Here's basic, sorry, go ahead, Giovanna.
oh, just one question about that may be stating the obvious for everybody. So CAPA notice issues are about, as you said, material noncompliance, serious nuisance, but you're not going to be dealing with those issues in a non-payment case. Is that right?
Correct. And CAPA notice is not required for serious nuisance, just for regular nuisance or for regular violations. The serious nuisance is an exception to the CAPA notice requirement. So if you are engaged in conduct that presents an immediate and serious danger to the health and safety of other tenants, or threatening a landlord, or engaging in substantial and willful destruction of the premises, those are exceptions to the general rule that lease violations or statutory violations get at first 47A15 CAPA notice. Here's a basic notice to quit. There's, again, hints there's a problem with this one as well. Let's see if you can identify it.
It's listed as having, as going to just Jane Doe and John Doe. And I guess if they actually know any of the occupants there, they would have to be listed specifically.
Okay, that's certainly one issue. The fictitious name pleading is generally disfavored in Connecticut, but you will see oftentimes that there's an exception to that in the statutes. So John Does and Jane Does are generally allowed to be named under the summary process statutes, but only if the landlord truly doesn't know their identities. And oftentimes you'll see landlords just add a few John Does or Jane Does just to cover their bases in case there's an adult child that has crossed over the age of majority since the lease was entered, or somebody that they're not aware is living in the unit that's an adult. There's one other issue with this notice.
Is it too vague? Because it just says termination of lease, so you don't know why.
Exactly. Thank you, Emily. Yeah. So termination of lease is not one of the statutory reasons provided in the statute 47A23. And so termination of lease could mean any number of things. Termination of lease due to non-payment of rent, termination of lease due to some condition of that lease, termination of lease because of the passage of time. And so the reasons stated have to comply and comport with what the statute's required, using the same or similar language as spelled out in the statute. And so if you see something that's not quite right, that's, again, slight variances are okay, but something like this that could give rise to an interpretation of multiple grounds would not be acceptable. That would be a jurisdictional issue. And part of the reason for that is the grounds under which the case is brought, if you enter judgment on that basis, that can create very different rights and remedies in terms of seeking a stay of execution, or just in terms of the practical effect of that case in the future. Certainly a case that was brought for a lapse of time or another no fault reason is very different than a case that's, for example, brought for non-payment of rent.
Is it a problem that it's not signed?
That's really just my own inability to sort of get it signed and get a version of this, since we generated this for the purpose of this training. But it would be a problem if it was not signed, yes. For the purposes of these, assume that they are signed. But every now and then you do see a notice to quit that's not signed, or where the landlord's not properly identified. Those would also be statutory non-compliance issues that would give rise to a jurisdictional claim.
Is the timing adequate, Cecil?
On this one?
Yeah, I can't remember
that
what
is exactly the issue. So tell me why.
Well, I'm trying to remember how many days are required, but it was served on January 13th, and the person has to leave within 7 days. And was thinking it might be more than 7 days.
So statutorily, this time frame is okay. It's only a 3-day quit period, but with a lapse of time case, just remember that the notice to quit has to be served during the term of the lease. And if you're claiming that the lease is lapsed by the passage of time, the notice also can't be premature. And so if I started a new lease at the beginning of the month, January 1st, then my right to occupy or my right of possession runs until the end of the month. You have a notice to quit. Upon service, it terminates that lease, but the term of the lease itself gave me until the end of the month. So this is a premature notice to quit only because of the term of the lease itself. And so for this notice to be good, it would have had to give at least until the end of the month or into the next month, so that the tenant was not required to leave prior to their right of possession expiring.
Just a sort of a practice tip, you may see notices to quit that have a quit date that goes beyond the term of the lease. And there's a small minor disagreements about this in the case law, but as a general proposition, that's okay. So a notice to quit that was delivered on the 13th either needs to give through the end of the lease, which is generally the end of the month on a month-to-month lease, or could say February 3rd. That's okay if it goes into the next month. The quit date can go into the next month, but the service date is within the month or the lease term.
May I ask a question? So it seems like you might have mentioned it and it didn't settle in my head, but so for example, it's served on 13th of January and it has to give at least until the end of January. Is there any minimum days before the end of January that it has to be served? You said 3 days or something like January 26th or something like that?
So ordinarily, a notice to quit only has to give 3 days to quit.
Okay. So
there are a few. One of the exceptions to that is, this is an exception where there's a lease in effect. Because there's still a lease in effect through the end of the month, it would have to give until the end of that lease term to be effective.
the latest it has to be served would be January 28, right?
So correct, it would have to be served during the lease term, and so it would have to give, it could certainly give beyond, to Nancy's point, it could give beyond the lease term. So if it went to, for example, February 2nd or 3rd, that would be fine, but it does need to be served within the lease term.
I mean, what I'm saying is that you can't serve it on the January 20th, 30th or 29th and say vacate by 31st.
You could, so long as you gave at least the statutory minimum 3 days and that the quit date did not precede the expiration of the lease. So that's the case where the landlord, if they wanted to do it properly, could serve it on the 29th, they could serve it on the 30th, but they would need to give at least 3 full days. And so that's a case in which you would, if the landlord were doing this properly, would provide a date in February for the tenant to quit.
Okay, thank you.
Just another practice tip. It's not terribly uncommon to find that if the parties have a written lease, that the written lease might give a longer period of time. The written lease might say any termination notice given to the tenant or some such language must provide 30 days notice. It's not uncommon. It doesn't happen in every lease, but take a look at the lease. There might be terms that the landlord needs to comply with that would give your clients more rights and raise jurisdictional defects on the notice to quit.
Nancy, Cecil, can I jump in with a question?
Sure.
If you had a written lease at the beginning of the tenancy and that written lease wasn't renewed, it went to month, would a lease provision requiring a certain period of time still apply when it's month to month, or would that lease term no longer be applicable?
That's a good question. You have to look at the terms of the lease. Most written leases have a termination clause, but many of them also have a holdover clause that say things like, at the end of this lease, if we have not extended this lease in writing or some such thing, the terms of this lease shall continue on a month-to-month basis. So often the holdover clause will tell you whether or not the terms of the written lease continue Sometimes there isn't a holdover clause, or sometimes the holdover clause specifies that the terms do not continue. Sometimes the lease specifies that it's the agreement of the parties that at the expiration of the written lease, if a new lease is not signed, that the relationship continues on a verbal month-to-month basis. So you want to look at the lease. It's more common, I would say, than not to have a holdover clause that gives you instruction on what terms will still apply.
And I think in the absence of any provision, there's a statutory presumption that it's a month-to-month lease. And so that would control. All right, let's go to the next one. So similar notice to quit, assume that the date is proper on this one, but it's a lapse of time. And in this case, your client is 68 years old. What's the issue? Or what should you be watching out for?
If you're over 62, the rules are different.
Correct.
I'm trying to remember whether there are additional defenses or exactly what the significance is, but I know there's a cutoff there in terms of age.
So a couple of things. So the ground for the eviction is lapse of time, so no fault eviction. And Vaughn, you're correct that 47A23C provides a good cause protection for tenants who are 62 years of age or older, or who are disabled, and occupying a building that has at least 5 or more units. And so were you to meet this client with this notice to quit, has lapse of time, you know they're 68 years old, you can see that they occupy unit 7B, confirm that there are likely to be more than 5 units in that building, your client is eligible for good cause protections. So an eviction based on lapse of time could not be brought against that client. It would have to be for non-payment of rent or some other cause basis to be proper. So good job on that one. So in the next set of facts, you have a lapse of time eviction. Again, assume that the dates are correct. You have a situation where this is served on January 13th. You know that the client has continuously requested of repair or replacement of an unoperative stove in December of 2020. Client is also dealing with some rodent infestation issues and has requested that those be repaired or addressed, and has made those requests by text message. And there's also been a complaint to Hartford Housing Code about these issues. What issues are potentially raised by this set of facts? What
Retaliation.
Retaliation.
Okay. And which of the retaliatory provisions are you likely to proceed under? Maybe getting a little bit more tricky, but. So something to remember is that there's, sorry,
20.
Right. And so this is a situation where just based on the dates and the facts, your client has probably met the standard to raise a rebuttable presumption that this eviction is retaliatory. That's 47A20, and then 20A allows or enumerates the grounds under which those can be, or that presumption can be rebutted. But here, obviously, the dates line up. Notice to quit was served within 6 months of the tenant engaged in certain protected activities as spelled out by the statute. And so there's a presumption that this is retaliatory. And that would be raised as a special defense in the matter when you get to representing the client in court. Same facts, but now assume that the landlord texts the client on January 12th, saying with the message that is at the bottom right here, calling the tenant a pain, saying that if they're so unhappy with the unit, why don't they move out, and alluding that they're sending them a special gift tomorrow, that special gift being this notice to quit. What issues does that raise?
No rebuttal. Does it create like a not rebuttable presumption that, you know, kind of convince like conclusory proof of retaliation?
Yeah, close. So 47A 33, there's two retaliatory eviction statutes, one of which is 47A 20, which creates the rebuttable presumption, and you just have to establish that you engaged in certain protected activity within 6 months prior to the giving of the notice to quit. 47A 33 allows an affirmative defense when the tenant can prove that the sole basis for the eviction was retaliation. And so part of what this is intended to bring up is that here, where you have a text message sent the day before the notice to quit is given, making it clear that the eviction is being sent in retaliation for the tenant engaging in these requests for repairs and complaints to housing code, you have a stronger argument under 47A 33 and don't necessarily need to get into that back and forth of establishing the presumption and rebutting it. You'd probably assert both special defenses. This is also an alert just that landlords and tenants are texting each other a whole lot. And so oftentimes we ask our clients to, share those text message exchanges because the exchanges that are happening, because they're by text, they can be established. There may be defenses that arise here. This particular text message, it's clearly intended to be quite obvious, but it makes it very clear, both in relation to the service of the notice to quit and on its own, that the intent behind the service of the notice to quit was a retaliatory one. This one's a little different. So here you have a notice to quit alleging non-payment of rent, and you'll see that there's some new language in the notice to quit, which is commonly referred to as a use and occupancy disclaimer. And so that's the line that appears: any payments tendered after the date specified to quit possession above will be accepted for use and occupancy only and not for rent, with full reservation of rights to continue with the eviction action. So assume that this is served on January 13th and your client makes a payment on the date specified marked January rent and appropriately tenders that to the landlord.
If the landlord accepts it, does that create a new tenancy?
Correct. Yeah. So because the use and occupancy disclaimer only goes into effect after the date specified to quit possession, the tenant's tender of rent prior to that date to quit possession on January 14th serves to reinstate the tenancy. Rent is, it's tendered as rent, and presumably because the use and occupancy disclaimer does not go into effect until after the date to quit, or until the date to quit possession, it's accepted as rent as well. So this probably gives you a special defense of tender and acceptance of rent prior to the termination of the lease or during what is effectively a cure period.
Cecil,
yes.
What if your client had tendered after the date, but had written in the memo line rent? Does that have any significance in terms of if the landlord accepted it? And
yeah, ordinarily not, just because if the use and occupancy disclaimer is contained on the notice to quit, that would control. Sometimes you see situations where a landlord fails to place a use and occupancy disclaimer on the notice, in which case, a tender with that kind of reservation or with that designation on it should be accepted as rent or should be recognized as rent. It would have to be asserted as a special defense that, that tender was made and accepted as rent.
Just another practice tip perhaps is always look at the return of service, because even if the dates on the notice, the quit date and the service and the date it was issued by the landlord or signed by the landlord do not give you opportunities to raise defenses, the date of service might be several days later. So even if the notice to quit does have a use and occupancy reservation, perhaps it's signed on the 13th, but it may not have been actually delivered to the tenant until the 16th or the 15th, and perhaps the tenant offered before then. So you need to look at the operative dates, not only what's listed in the notice to quit itself, but the return of service, which will be posted on the court website.
Cecil, Nancy, this is Greg. I've got a question. I mean, I know in this example, it looks pretty basic in the sense of, you know, they missed one month or, you know, paid a little bit late there. But what's more common for the cases that we'll see? I mean, I'm assuming that it's probably more than just 1 month's rent that was late, or is there an average amount of time that you frequently see in these cases of late payment or non-payment rather?
Oftentimes, I think if there's something else going on, you'll see the case where, you know, the landlord sort of waits for that 1 month missed rent or the late rent and uses that, you know, it's really about something else. And so if you've got a hook to claim non-payment of rent, you'll claim it because there are less defenses to that. In that type of situation, you'd probably raise an equitable defense because the harm to the tenant would greatly outweigh the harm to the landlord, where the tenant is ready to make the landlord whole. But frequently, especially of late, because of the impact of COVID-19, we are certainly both have seen and are expecting to see situations where the amount of the arrearage is greater. The other thing I just highlight is that under the statute, in a month-to-month tenancy, even though there may be other claims, jurisdictionally, you're limited in a month-to-month tenancy to the month of service of the notice to quit, and you're permitted to go 1 month prior. So even though the landlord may have some broader claims for unpaid amounts under previous month terms, or previous terms of a lease, generally speaking, they're limited in a month-to-month tenancy to the month of service to notice to quit and the month prior to that.
And as a practical consideration in representing your client, exactly what Cecil said, you may see on a month-to-month that the landlord has no basis to go further back than 1 month, but the tenant might owe 6, 8, 9 months before that. And so there might be a huge arrearage, but the eviction itself is based on, you know, non-payment of January or non-payment of January and December of the prior year. So that comes into play when you're talking about settlement, and the rent programs that Cecil highlighted earlier in the training will also be very important to that point, the rent assistance programs. Because a landlord may bring an eviction on a month-to-month lease, but not be willing to discuss settlement unless the tenant is going to pay the whole arrearage, not just any arrearage upon which this actual eviction is based.
So this next one, non-payment of rent claim, served again January 13th, 2021, but you have the same set of facts that the client has been requesting repairs to. Inoperative stove, they've got the rodent infestation, they've made complaints to the Hartford Licenses and Inspections Department and have a report documenting the inoperative stove and an order to replace it. What issues does this implicate?
Is it that the rent wasn't actually due because the landlord didn't provide essential services and violated various building codes?
Perfect. Yeah. So you're going to want to look at Connecticut General Statutes 47A4A and 7. 4A says that that effectively no rent is due when the landlord has failed to comply with their statutory obligations, which include the obligation to keep and put the premises in fit and habitable condition. So effectively, it's a habitability defense. And so you would assert that as a special defense, asserting that the conditions in the unit were such that no rent was due under the statute. Here you have the same set of sort of dates and the same claim, except that the issue is one where the client's window blinds have been in the unit since she moved in. They're more than 10 years old. They're in significant disrepair. Client has texted the landlord asking for repairs or replacements continuously for the last several years without response. And then finally, the client, in frustration, withholds the full rent for January of 2021 and texts the landlord that she was withholding the rent because he had not replaced the window blinds. What are your thoughts on this set of facts? do you all think that this implicates habitability? Is it likely to raise the same statutory protections that we discussed in the last set of facts?
No, it's kind of too mild.
Yeah, it seems to me rodents are probably a bigger problem than just the lack of blinds. Obviously, if like a window wasn't there, that's a different story, and it's the middle of winter. But this doesn't seem like it's enough.
Yeah, you're correct. But go ahead.
Oh no, I was just going to ask if you ever advise clients to unilaterally withhold their rent.
Not often. A lot of it is very fact specific, but oftentimes we don't have the opportunity to give that advice if the client has made that decision. Sometimes it's just a mistake in understanding what the law allows. This is another one of those situations where I think there are some myths out there about what is permitted and what's not. In part because I think if you were to read those two statutes, 47A4A and 7, read strictly, it would suggest that a landlord's failure to comply with something that could, rise to the level of a citation or doesn't meet their obligations under the applicable municipal code could excuse the payment of rent. But when you look at the interpretation of those statutes as applied by the case law, they've generally looked for the conditions issues to be such that they rise to the issue of habitability. And so you may, in this case, there may be equitable arguments to be made. There may be, a claim for some sort of equitable offset, but it's not likely to be a situation given the severity of the issues that will excuse the full non-payment of rents for a full month of rent. Tenants in this circumstances, they do have other remedies, one of which is a payment into court action. But if they've already had a notice to quit served on them under the statute, they are not permitted to pursue a payment into court action until after that case is resolved. And so it may be something that you consider as you're working with that client, that if they have a case where there's underlying conditions, you're successful in prevailing in that case, that the next step, assuming the client is amenable to it, it would be an initiation of a complaint to housing code, waiting the 21-day period that's required by that statute, and then initiating a payment into court action where the tenant is the plaintiff and is paying their rent into court, and so has the benefit of an affirmative posture as opposed to a defensive one in a non-payment of rent case. This one is basically two set of facts drawing from the same notice to quit. So you have a notice to quit, non-payment of rent, serve the 13th, quit date the 20th. Those dates are fine. But per the custom and lease of the parties, rent is always payable at the unit. And for January of 2021, the landlord did not come to collect the rent, instead serving this notice to quit. What issues does that raise?
I think they'd be able to argue that they had the rent available and he should have come to the unit as per the custom that they've established to pick the rent.
Yeah, and so that's a tender. If the tenant was available at the unit in the customary fashion, had the rent available to them, and the landlord simply didn't come or didn't make arrangements to collect that rent, they don't get to pursue a claim for non-payment of rent, because the tenant being present at the unit and available to tender the rent constitutes, under the case law, a tender. Now assume that the lease provides that rent is payable by mail, and the tenant has placed his rent payment properly addressed and stamped in the mailbox in front of his apartment on January 10th, so it's otherwise timely. The landlord doesn't receive that rent and serves a notice to quit due to non-receipt of the payment on January 13th. What issues does that raise, or what special defenses might you assert there?
I like arguing that it was a tender, but I have no idea if the case law would say that's sufficient since the landlord didn't receive it and accept it.
Yeah, so this is a situation where the Connecticut's mailbox rule would apply, where if the rent has been placed in the mail system and the landlord has established that as a method of delivery of payment, that the landlord then has borne the risk of that method of delivery. And so that placement into the mail system under the Connecticut's mailbox rule constitutes a tender in the same way. And so, again, part of the exercise here is to recognize that the notice to quit is the landlord's unequivocal termination of the lease. But until such time as the lease is in fact terminated, a tender will stop the termination of the lease. And so you may be looking for fact patterns in which there was a functional tender, or to the earlier examples where there's an excuse for failing to pay the rent or withholding the rent in some way because of conditions issues.
Question, Cecil, in practice, how does that kind of end up working, right? In terms of, I mean, you hear that, right? The check's in the mail, right? Kind of, how does that, from a practical perspective, kind of work then when you try to defend that?
Yeah, I mean, I think oftentimes you have to, in your best case scenario, the tenant sent it in some way that's provable, and that's not often the case. But if they can show that they've done that, we've sometimes proved that by circumstantial evidence. So if they, for example, can show that they withdrew money from their account, or that they have a receipt of some sort from the, oftentimes our clients will use money orders and will unfortunately have to use check cashing places. So if they have a receipt for a money order obtained on a certain date, you know, those things can be established that way. But again, you know, where the tenant sort of can show in some way or testify that they have placed in the mail system, the judge would have to credit that testimony, but it is a valid defense and should be asserted that there was a tender in advance of the termination of the lease.
I think luckily most of our clients are used to paying rent, especially rent that would be mailed in by money order. And it would be, I think, probative to a judge if the money order was purchased on or before the date that the tenant claims they mailed it. So that's always the first question I would ask is, do you have a receipt for the money order, or a photocopy or a tissue copy or something to show me that you purchased the money order before the 10th of the month or on the 10th of the month? Because often tenants will purchase a money order and mail it that same day. The other thing, the few cases I've had where this has come up, and it hasn't come up often, but if a landlord claims non-receipt and the tenant claims I mailed it, if the landlord doesn't have a postmarked envelope, I think that's also a problem for the landlord. If the landlord has a postmarked envelope and it's postmarked the 11th, you know, then the tenant is left with claiming, well, I put it in the mailbox, I can't help it that it wasn't picked up. So I always tell my clients, I mean, you're gonna have them after this, but I always tell folks, if you're making a payment, make sure you mail it from the post office, or make sure that the post box has a pickup that hasn't already happened. We have very few post boxes left in Hartford, and often they're, you know, 11 in the morning, and if you mail it at 2 in the afternoon, it's gonna wait a day.
So here's another one. So here you have, again, the same notice to quit, non-payment of rent, served January 13th. And then on January 20th, you have this text from the landlord saying, where's my rent? I'm coming over there tomorrow to pick it up. You owe me $1,200 in rent and $50 in late fees under the lease. You better have it for me. Your lease is also up at the end of March. Are you planning to renew? What issues does this raise?
The landlord just made the notice to quit ambiguous by his conduct.
Exactly, yeah. So getting back to the requirement of the notice to quit be unequivocal, anything that would suggest that the lease is still in effect, any demands for rent as opposed to, you know, use and occupancy could sometimes be used as a way of asking for payments, but generally there has to be a very clear manifestation of the landlord's intent, not only to bring the eviction, but also to maintain it. And so if you have here, landlord is attempting to assert certain rights under the lease, late fees only arise under the lease. Rent is inconsistent with the termination of a tenancy. It only really arises under lease. and also just discussions of renewal of the lease. All of that tends to send the message that the termination of the lease actually never happened. And so this is in fact a jurisdictional issue. It's a little bit strange in the housing court because oftentimes these jurisdictional issues that rely on some additional facts are presented as motions to dismiss, notwithstanding the fact that they require resort to some additional facts. And the courts have generally been receptive to that, notwithstanding the general standard of motions to dismiss. So if you have these types of facts, raise them. And you'll see this more often than we'd expect, just because a lot of landlords have automated, rent demand systems, and they're sending out these notices seeking to collect the rent, or will continue to use the eviction process, which is limited to the question of possession, as a way of gaining leverage and obtaining payments. And the law is quite clear that once you've chosen to terminate the lease and take this path, the landlord is not permitted to continue to make demands or act as if the lease was never in fact terminated. And so that's gone up to the Supreme Court on that issue. There's a case called Centrix versus Valencia, which is in your materials, that establishes what the standard is for when a landlord equivocates their own notice to quit. Something to pay very close attention to, again, because of the extraordinary remedy that's provided by way of summary process.
Just a practice tip, I would refer you back to Cecil's prior comments about reviewing texts between your client and the landlord. A few years ago, I wouldn't have routinely asked about texts. Now, it's one of the first questions I ask because there's so much to be made from what the landlord and the tenant text back and forth to each other. In addition, when you're making plans to meet with your client or gather documents from your client, you ask for all the normal things, the lease, the rent ledger, eviction papers, things like that. But what I've started telling folks is bring me anything that even remotely deals with your landlord or your apartment, even if you think it doesn't apply, even if it's old, even if you just got it yesterday. Just give me everything that touches on your rental situation, and then I'll sort through it. And I'm amazed time after time, the things that the tenant will bring that maybe they don't think are relevant, that will have conversations, letters with offers of rent. I've seen new leases signed. So just ask your client for every speck of documentation they have.
So we'll close there. I know we're running up on time. Certainly if you all have any questions, both from the first training or arising from this training, happy to take some time to answer those now. These are our direct lines and our email addresses. So if you take a case, we are here to answer your questions. This is a lot of information. It's what I think learned over the course of time that I've done this is that it's almost never just about the issue that's originally presented, and that summary process law can often take you into related areas and issues. But we're here to help. And so one, we're incredibly grateful to all of you that you're willing to take on these cases. Two, I would just reemphasize exactly how important housing stability is to our clients and what a crucial element of that you all will be by helping with these cases. And three, again, if you need us, this is how to reach us. We are here to support you as you undertake these cases. So welcome any questions that you all may have or comments. Certainly happy to do that beyond today. But if any of you have any questions at this moment, please feel free to raise them.
Cecil, I just signed up for this Zoom meeting yesterday, and I haven't gotten any materials. So I don't know if I should send you an email about that or.
We can send you the manual, Curtis, and the link to the YouTube video that Cecil put together for CBA is also really helpful.
Right. Okay.
But we'll send you the manual. And we will also have forthcoming information about how the referral process will work as we move into this anticipated high volume time. Sue Garten, who's the managing attorney of the housing unit, and I will be getting that information out to you as well.
Okay, thanks.
Other questions? Thank you, Cecil and Nancy, for a wonderful interactive presentation. I certainly learned a lot, and thank you too to all who joined. We had a really good turnout of 18 pro bono attorneys representing a lot of great firms, and we're just so grateful that folks are willing to assist our clients and our neighbors in this capacity. So thank you.
Thanks all, appreciate it.
Thank you.
Thanks.
We'll make the recording available. Signing off now. Thanks, everybody.
Thank you.
Thank you.